May I apologise for keeping you all waiting for a few minutes. We were just looking at Mr. Justice Peel's House Rules of May 2023.
My ladies, my lord, please the court on behalf of the Appellant Local Authority.
Could you speak up a little?
Sorry, I appear on behalf of the Appellant Local Authority.
Yes.
Sitting behind me is my instructing solicitor, and behind her the social work team of the allocated social worker and team manager.
Yes.
Representing the first respondent mother is my learned friend Miss Burnell, King's Counsel, and her learned junior Miss Mallon. And representing the interest of E is my learned friend Miss Edmonds, and sitting behind her is her instructing solicitor. I hopefully have introduced everybody in court.
Yes, thank you.
Ladies, my lord, this of course is an appeal against the order at first instance on the 22nd of March 2024. The appellant local authorities grounds in relation to that appeal essentially are that at that hearing, and indeed the hearing that preceded it, the court has made, I use in inverted commas, orders in relation to contact. We say within recitals initially, but certainly within the transcript that my ladies and my lord have in relation to that hearing. The judge at first instance clearly stipulates our orders of the court in relation of the contact that should take place between E and her mother. My ladies, my lord, in relation to the first hearing, it is accepted that there was, for want of a better expression, a roadmap in regards to the introduction of direct contact between the child E and the mother. And by the time the matter had come back before the court in March, the local authority had considerable concerns in relation to the progression of that contact by virtue of the 3 video contacts that had taken place, and had therefore made an application pursuant to section 34(4) of the Act in regards to seeking the court's permissive authority to suspend contact in relation to the progression of direct contact.
Can I just clarify a couple of things? First
Certainly.
of all, so far as the chronology is concerned, so far as the first hearing is concerned, am I right in thinking that the roadmap, as you've described it, was something in terms of which were agreed by the parties outside court after the conclusion of the hearing, and were then incorporated into the recitals that we've seen?
My lady, it was effectively dealt with in 2 stages. The local authority had its position as set out within the initial SWET, which was it wasn't advocating direct contact at all. We then, as is common practice, appeared before the court, and the learned judge at first instance gave his indication in regards to what he saw as an appropriate level of contact. The matter was then stood down and the parties reflected, indeed the local authority reflected, and took on board effectively what the learned judge had said, and therefore the parties went into court with that roadmap, which was then approved by the judge at first instance at that first hearing. So that is the origin of how the roadmap comes about. It's not placed within the order post the hearing. It was the local authority reflecting on the observations of the court.
Thank you.
So that's how those the chronology of events in relation to that took place. At the hearing on the 22nd, you will see, my ladies, my lord, in relation to that hearing, that the local authority will say that the learned judge should have, in any event, reviewed the issue of contact without invitation, effectively, but indeed was invited to reflect in relation to the roadmap and the workings of it, notwithstanding the application for 34(4), but by virtue of the fact, in any event, the local authority had said, we've made an application pursuant to 34(4).
Now, as I understand, the local authority Well, regarded that as a backstop if necessary, because
Yes.
you were saying what you were offering was reasonable contact.
Yes.
But you weren't actually asking to suspend contact, were you? Because your plan was that there would continue to be some indirect contact by video link.
Indeed.
That it may not matter, but arguably that might have been better under Section 34.2 than in Section 34.4, given that you weren't actually asking for permission to suspend.
Perhaps.
I mean, it probably doesn't matter,
Yes.
because what you were doing, the local authority say, is that you were using it as an insurance policy if
Yes.
if the judge disagreed with you that what you were proposing was appropriate.
The lady, that is a phrase that wasn't used by us, but it's entirely correct, and accordingly, if I may be forgiven for adopting it. The 34.4 indeed was an insurance policy, and the local authority's position was effectively that its duties to promote contact in the context of E, and the risk factors surrounding it, and the additional evidence that had come to the court following the first hearing, was such that in reality, promotion of contact would be, to the court's satisfaction, we would have said, at the continuation of the video contact. There was a dispute in relation to the authorities' approach in regard to that and the mother, and I don't take any issue with them taking a different stance. This is why the judge had to adjudicate upon it, because the local authority was saying that the video contact at the rate of 1 session per week was appropriate, and we would continue to observe that. At the same time, acknowledging we may need to review that either way, either by increasing it or applying further in regard to suspending it. Mm-hmm. The mother, initially at least, was saying that should be elevated to at least 2 times per week.
Well, my understanding from reading the transcripts and the papers was that effectively outside court an agreement had been reached, a compromise had been reached, and it was agreed that there was to be video twice a week, and then looking to progress in due course.
Yes, and indeed...
And that changed when Ms. Mallon, who then represented the mother, moved away from that agreement because the judge seemed to be indicating direct contact.
That's indeed correct. It has to be said, and of course I will give way in due course on this point, it wasn't the mother wishing effectively to have the continuation of video contact. She wanted direct contact, but outside of court there had been a recognition in regard to the position, and accordingly that compromise. The authority would say that the learned judge himself, during the currency of that hearing, seems to have taken the view that the local authority have effectively ignored an order of the court, and that is therefore the starting point. And it is at that point that perhaps understandably...
He doesn't even seem to have realised that an agreement had been reached outside court.
No. But
he seems to have thought the agreement outside court was twice a week direct rather than twice a week video.
There does seem to be that confusion, but perhaps in any event, my lady, the learned judge seems to have adopted the starting point that an order has been made and the local authority flagrantly disregarded it. There's a question in regard to the court's stance in regard to that, but that seems to be on the authority's case where the starting point of the learned judge was, rather than looking at the compromise. And indeed, in regard to that compromise, the court then undertaking its own analysis of saying, well, when we look at the risks, is that compromise in itself appropriate? But it seems that the issue in and around direct contact and the court's orders and so on and so forth appear to have been elevated over and above the welfare analysis and the local authority's application, which seems to have, at some points within the transcript, been acknowledged on the one hand as being made, and then later on seems to come as a little bit of a surprise to the judge.
Well, that's politely put, isn't it? I mean, he appears to have gone through a not insignificant amount of that hearing in ignorance of the fact that the 34.4 application had been made.
Milady, yes, it seems that that is the case, because Milady will be aware that I bring that to the judge's attention
Yes,
by way of clarification.
which you did in very courteously, if I may say so.
Not at all.
So what we have is the judge saying that he had effectively made an order, that the order had not been complied with, and that order had to be put into effect. And we don't see any welfare evaluation, either generally or against the backdrop of the statement.
No. In essence, Milady, that is it. And of course, the local authority will go a little bit further than that. Even if the local authority hadn't applied and had ignored, and I'm not saying the local authority should, but if there were reasons why they'd not been able to implement an order or the indications of the court, consider the reasons why in regard to that welfare analysis. It is, of course, important that the court has all of the information before it, and I would submit it was right that the local authority took the decision to make the application for a 34-4. But in any event, it seems that that was the first, second and third issue and central thought of the court, rather than the welfare analysis, even if it had been found that the local authority were wanting in regard to disregarding the court. But we would submit we didn't in any event. And the correct review process in regard to the additional information, both in regard to the additional police information, but most importantly, the reactions of E. And again, in regard to the reactions of E, the authority would submit that the learned judge appears to have taken what we were saying as effectively ascertainable wishes of E, saying, I don't want contact. And of course, the authority weren't elevating that. We weren't saying, of course, that a child of that age's ascertainable wishes are listened to, but that information from E being evaluated by the social work team on the ground as an indication set against the risk factors in regard to it's accepted the factual matrix isn't fixed, but the allegations that the local authority bring the case on, which we would say, of course, are at the more serious end of the spectrum.
Well, there were a number of reasons why E might have been taking that position in relation to contact, one of which was because of the alleged abuse upon her by her mother and Mr. A. But there, of course, were other possibilities, and you say that the judge wasn't in a position to make any determination of what that range of possibilities was, at this particular point, and should have been more careful in the circumstances, given the risk of harm as part of the Section 1.3 checklist.
My Lord, yes, it appears that it's almost been looked at in a silo in regards to simply, I'm dealing with this as ascertainable witches which should be rejected, rather than looking at it in the round of the risk factors that my Lord refers to.
Well, what he was saying is, I've made an order, you've not complied with the order, and now you're coming along and saying that what a 3-year-old says goes.
Yes, effectively. Which the local authority would say has led to an outcome that has accordingly led to where we are today. And in essence, if those matters had been correctly gone through and not the starting point of the despondency at the local authority not implementing orders, the outcome would have been, we would say, would have been a different outcome in regard to that welfare analysis, which is absent.
There's no analysis of risk at all.
There isn't. And my lady, I on behalf of the authority, I accept that this was a Friday, it's a Friday afternoon. The judges at first instance are extremely busy.
Yep.
And of course, my lady will be that is a pressure that's increasing rather than diminishing. But at the same time, in cases such as this, that analysis has to be gone through in a calm manner.
But at the end of the day, this is a little girl who has spent a substantial amount of her time away from her mother in any event. Mr. A has pleaded guilty very serious allegations of sexual abuse, which took place on any view at a time when the mother and he were in a relationship. I know, of course, the mother is pleading not guilty, and so we have no idea what a jury will conclude or a finding of fact will conclude about that. But that places this child in an area of very high risk.
Yes.
I mean, obviously emotional, not... excuse me, I'm just getting over a bad cough.
A lady, yes. And in regard to that, when the learned judge talks about any risk factors being ameliorated by virtue of supervision, again in regard to that welfare analysis for the matters my lady has just raised, the local authority again would say, in regard to that welfare analysis, that is where the learned judge has fallen into error, because it's not a question of supervision to make sure there isn't a repeat of perpetration. It is those emotional factors that come from potentially being in the presence of the perpetrator of the allegations to which the local authority puts. And it's for those reasons that the local authority had made its position clear in regard to those matters. And again, in regard to that, the learned judge would appear to have not factored that into matters and simply looked at, can supervision prevent an affliction of what the local authority have alleged occurred? And we would submit that that, of course, can't be right in the facts of this case. So, in essence, that's where the local authority is at in regard to that failure as regards to the welfare analysis on that day and the information. Again, in addition to that, it does appear
I'm so sorry, I think I'm probably
Not
have to
to worry.
rise for a moment. I do apologise. As soon as you think you've stopped doing this, you start again.
All rise if able.
My second apology within the space of half an hour.
Not so. My lady, I don't know whether that was a subliminal indication that I'd spoken for too long. But in any event, I'm not sure at this point whether I can insist further, unless my lady's my lord. There are any particular points?
I have two points. I just wanted to check with you. E was accommodated under Section 20 after the mother's arrest. Initially, she went to live with her grandmother, I think, for maybe a day or so, and then went to the maternal great aunt.
Yes.
And between that date and I think it really was probably the 6th of March, but let's take the court hearing on the 27th of February as the end point. Between the 10th of January, when the mother was released on conditional bail from Style, till the 27th of February, she had no contact with E. What does the local authorities say about the absence of any contact in that period?
My lord, in relation to that, what is clear is that the local authority did not set out the rationale behind that. In the initial sweat, my lord, it makes reference to the local authority doesn't think, because of the facts and the welfare analysis, that there should be contact. But that is almost, it has to be accepted by us, almost a retrospective analysis of why there hadn't been. Under the auspices of a Section 20 placement, we don't say that the same duties don't apply, and then therefore analysis. That's a lesson to be learned, and we do have to accept that there hadn't been. It may well be that and I suspect it would be, that the local authority's decision making would have reached the same conclusion, but I do have to accept it's only within the sweat that we get that observation rather than analysis.
And you refer there to the duty on the local authority. That's a clear duty that's contained in statute, isn't it?
Yes.
Schedule 2, paragraph 15, responsibility of the local authority to provide contact, unless it's not consistent with the child's welfare.
My lord, yes, and I don't distinguish that from Section 20 and the making of the interim care order. We don't shrug our shoulders and say it was a Section 20, we didn't need to do that.
No.
The obligations
It's plainly there under Section 20.
Indeed.
Yeah.
And my lord, in relation to in effect, my instructing solicitor raises this point with me. The bail conditions, of course, said no contact unless ordered by the family court.
Right.
So we're perhaps dancing on the head of a pin at that point, but that of course was the bail condition in any event, of which the mother would have been aware.
Yes.
But it doesn't detract from it being incumbent, pursuant to Section 20, to incorporate that analysis as part of the Section 20 agreement,
Right.
which again should be kept under review.
Yes, I see. Well, that's helpful, I think the point is a reasonable one to make, that the bail condition did expect a family court decision around contact. It
Yes.
wasn't a local authority decision. Understood that. The second point I wanted to raise with you was in relation to recitals. Now, the judge made, first of all, the judge made it clear, did he not, in the hearing, that he was going to make an order this time round in
Yes.
relation to the contact between the mother and E. He says so, I think, more than once, but I don't think we need to find it. I think we can agree that. But in the event, it didn't, in fact, form part of an order. It formed part of the recital. Why was that?
Well, Lord, the acceptance of blame, for want of a better expression, must fall with the author of the draft. That was me. Upon reading the transcript, I was reminded that indeed there was not just the mention of it, but an effective insistence that I'm making an order. by virtue of that, the draft should have reflected the second order, the 22nd of March order.
Yes.
Should therefore have stipulated it as an order rather than a recital.
Right.
So I apologise, my lord.
All right. Well, understood. Although, just to be clear, your apology, of course, is accepted, but presumably the judge himself considered and approved the draft order before it was sealed.
It's certainly, as far as I'm aware, that is,
Yes.
of course, the case.
All right. And during the hearing, of course, so that deals with one aspect of the recitals. During the hearing, the judge referred to the 27th of February contact provision as being contained in an order. But of course, it wasn't, again, an order. It was a recital reflecting an agreement reached outside court. And there's a little debate that's opened up in this appeal about whether or not the recital could have been effectively enforced as if it were a court order. And there is reference to a decision of Mr. Justice Williams, and there's a reference to a decision of Mr. Justice Peel. And indeed, in the transcript itself, the judge makes a point that there is a decision of this court in which, this is page 13 of the transcript, where he says it wasn't just an agreement, it was, as we all know, the Court of Appeal said very clearly that recordings are part of the order, it's just a way. And then Miss Mallon says, yes, of expressing what the court wants to happen, so that was agreed, and it was ordered. But first of all, are you able to illuminate us on what Court of Appeal authority the judge might have been referring to there?
My lord, my only thoughts on that are effectively that is where he makes the distinction between the earlier authority. Bear with me, my lord. The BSA MVT case. I can only think, my lord, that that's the matter that he's referring to in regard to the observations of. Well, that's a High Court case, so I'm not sure whether that's the case he meant. I can't find where, it's perhaps my ignorance rather than anybody else's, where the Court of Appeal have said recitals are as enforceable, other than when the court has considered, such as in Reby, I think 2003, where there wasn't an order in a finding of fact, and can the court adjudicate in matters of judgments and so forth. But in regard to recitals specifically, so that the court didn't have, well, the parties didn't have any recourse. So, for example, in this case, if it was simply recitals and the court said you can't enforce a recital, but there is a clear judgment saying this must happen by virtue of recitals, the local authority wouldn't have any recourse. But I have to say, I'm not aware of where the Court of Appeal, in an instance such as this, had said, in terms that the learned judge set out.
And what is your position?
In regard to recitals, we would certainly, and this is where we come to the first order, that recitals are different to an order, save for example, in a money case, if the matters within the recitals can't form part of an order, but form part of the full picture. So therefore, if you couldn't enforce the recital, the whole basis of the order falls. Whereas a recital in this case, Parliament has made the distinction by saying there is the provision to make an order, and by virtue of that, it's accepted that normally the matters are set out by way of recitals because the court isn't invited in each and every care case to make an order for various reasons. So we would submit that there is sufficient to seek relief in relation to recitals, but shouldn't be treated in the same way as an order. Therefore, the local authority is in breach of an order, which we would say the learned judge in March said effectively that the local authority were, that his recitals were as enforceable as orders. Therefore, we shouldn't have ignored them, and effectively the local authority is in breach, and that, we would say, set in train the course of thought that the learned judge took.
So if there'd been a welfare evaluation and determination, it should be in an order.
Yes.
If it is to, if set aside the house rules for a moment, but if prior to the house rules it's being done as a means of reassuring
Yes.
one of the parties of the good faith of the local authority as to what they intend to do to promote contact,
Yes,
then that could go in a recital.
absolutely.
And you say that this first, the February order, is the form is a recital because the local authority, having heard the judge's view, albeit that it wasn't after a full welfare evaluation, had reached an agreement outside court, and that was reflected as a matter of good faith in the recital.
Indeed.
And the judge was in error in suggesting that that could be regarded as an order.
Indeed. It doesn't allow the local authority to throw it in the air and say, it's only a recital, we don't care. It is a reassurance, and the parties must be able to have that reassurance. But the learned judge elevated it in regard to saying you've breached my order.
Thank you.
Thank you.
Yeah, that's fine. Yes.
No, thank you very much. That's most helpful.
Thank you.
Yes, Miss Bennell.
My lady, perhaps if I start with that last point, in fact, if that would assist.
Of course.
My lady, it is something of an interesting point because, my lady, we too cannot find any Court of Appeal authority for the judge's assertion that this court has determined that recitals are enforceable as orders. My lord, we too wonder whether he had in mind BSA, which was an appeal, albeit of course not an appeal dealt with by this court. My lady, we have undertaken that search for the relevant reference.
Thank you.
As to whether a recital ought to be as enforceable as an order, my lady, we do not seek to persuade this court that it should be enforceable as an order would be. Because, my lady, it's the obvious point. If the court was being invited to make an enforceable provision, there is a statutory provision under which that can be done and an order can be made. That said, my lady, the events of February are common when dealing with this sort of issue before a first instance tribunal, particularly, as has been already said by the local authority, a busy circuit judge or even district judges dealing with these sorts of matters. It is not at all uncommon, of course, for the parties to have differing views as to the frequency or nature or mechanics of contact, for the judge to be invited to express a view and the parties either to reach agreement in the true sense of the word, as in February, where they went outside and reflected and negotiated a way forward, or in fact really submission to the judge's direction with a local authority, if it is against the local authority, perhaps just accepting the judge's indication as the way forward and what is going to happen.
If they do that, then that should be in an order, shouldn't it? If there's been submissions, so the judge has heard both sides on the welfare aspect of the case and has then given a strong indication or a ruling, effectively.
Well,
should that not be in an order?
My lady, I think it rather depends, or I would submit it rather depends on the position of the local authority at that point. Sometimes, having heard the judge's strong indications to what should happen, in fact, the local authority will say, OK, we will now put plans in place to give effect to the judge's indication. In those circumstances, it is still I think in our probably collective experience, not unusual for that to be in a recital. And my lady, the reason for that is probably self-evident, but my lady, it's touched upon by Lord Justice Peter Jackson in the DS case, paragraph 13. He talks about there may be many reasons why one may want a degree of flexibility. He is considering...
Sorry, paragraph?
It's paragraph 13, my lady.
That's page 109 of the authorities bundle.
Where he is considering there may be a number of reasons why a judge may make an order under section 34 or not. Maybe he talks about the broad discretion that the court has as to whether or not to make an order, may decide applying the no order principle not to, because it's broadly equivalent to the contact that's being offered, or, and my lady, it's particularly in my submission, the second part of that sentence, that it is often relied upon or referred to by local authorities. The making of an order may lead to a loss of flexibility, or because of the practical considerations that make the ideal level of contact unachievable. My lady, we submit that is particularly so in the early stages of proceedings, just as it was in the present case, where there is still much to come in by way of disclosure, materials from other agencies, and where contact is really only just getting off the ground, as it were. And therefore, how viable, achievable, practicable that judge's indication is, there may just be flexibility in changes. It's not at all unusual for contact to change very regularly throughout the lifetime of the case. So, my lady, even in those circumstances, where there is a strong indication of acquiescence, it is regularly not included within an order to allow for that flexibility and for that looked after children review process that has to take place. So, my lady, I don't seek to persuade this court, as I indicated, that a recital is as enforceable as an order, but my lady, really just to make the point,
they have their place.
Used, and they're used a lot in this sort of situation. My lady, turning to the appeal itself, my lady, in effect, we submit that this appeal is in many ways premature at this stage. Because, my lady, if we start from the position that notwithstanding the judge's observation about recitals being enforceable as orders, in fact, there was no enforcement application before him, if the recital in the order of the 27th of February was not enforceable as an order, nor was the recital, which was as it was drafted and approved, we may need to come back to that matter, but the recital as the contact in the March order. If the local authority were not bound by that recital, of course we say, well, the local authority could have indicated to the parties, we don't consider ourselves bound. That is not what we are going to offer. At which point, should the mother wish to pursue matters further, she could have applied, of course, under section 34. And therefore the matter could have been heard and ventilated, whether by His Honour Judge Greensmith or another judge. My lady, this appeal in our submission is somewhat unusual because it is, of course, an appeal against a recital, which is what the order is on the face of it. My lady, we submit, and we've set out within our skeleton argument, we have to accept that the reasoning given by His Honour Judge Greensmith was brief. It does not go through the matters set out in the welfare checklist one by one. That is self-evident from a reading of the transcript. My lady, where we depart from the local authority, and indeed that which is set out within the Guardian's skeleton argument, is as to whether in fact there had been an agreement reached before the parties went into court. The mother in this case finds herself in a very difficult position. she had had an indication from the judge on the 27th of February that direct contact should take place. Indeed, she wanted direct contact with E for understandable reasons. That was then accepted by the local authority when there was the out-of-court negotiation as to a way forward. And my lady, perhaps pausing there to note, whilst the local authority, of course, indicate these are serious charges faced by the mother, they are charges that must be, and allegations faced by her within these proceedings that must be taken into consideration as part of the determination of what is in the child's best interest. That was known in February when a planned way forward was agreed by the local authority, the guardian and the court. So that was, as it were, the way the mother thought that this matter was going to progress. It didn't, and in fairness to the mother at that stage, she worked with the local authority to have more indirect FaceTime video contact. She did not make an application under Section 34 to try and enforce. She was mindful of the balance that needed to be struck and wanted to continue to work with the professionals. By the March hearing, my lady, there certainly were, we accept, discussions about continuing with indirect contact for a period of time.
Outside court.
Yes, my lady, yes. The frequency of the indirect FaceTime contact was not agreed.
I thought it had been agreed twice. Initially, the local authority said once. Mother said, I'm not sure if she said 3 first of all, and then 2. But
my lady, the mother did say did want 2 at one point. What had been suggested was, well, how about we try twice a week FaceTime contact? But my lady, the local authority's position had remained that the FaceTime contact should be once per week.
might taste that bit in the transcript that deals with that, would you please?
Of course, my lady, just bear with me 1 moment.
Here, I found it, page 5.
And my lady, indeed, that remains the local authority's position. It was the position that was set out in the statement of the social worker, and remains the local authority's position that it should be.
So the agreement was that it would carry on as indirect contact by video, but they hadn't reached an agreement as to whether it should be once or twice a week.
My lady, they hadn't reached agreement as to whether it should be once or twice. They also hadn't reached agreement as to how long it should be before that indirect contact was reviewed. The mother's primary position at that hearing in March was that she wanted direct contact to start.
Not when she got into court, it wasn't. When it got into court, there'd been an agreement that it was going to carry on being indirect for a unagreed period of time.
My lady, yes, but my lady, her primary position was she wanted the direct contact to start as soon as possible.
Understood.
And that, in fact, has always been her position. My lady, of course, reading the transcript with the benefit of hindsight, of course, it does appear that there was confusion on the part of the judge as to whether any period of indirect, with the duration of that was in dispute, whether any period of indirect was being agreed or suggested on behalf of the mother. And indeed, Miss Mallon asked for clarity as to whether the judge is in fact directing that contact should be direct. My lady, we submit, of course, it was open to the judge to take a different view to the parties if he considered that direct face-to-face contact was in the interests of E. My lady, I have to accept, of course, this isn't a judge who says, because of that confusion, well, actually, I appreciate you've agreed one thing, but I disagree with you, because he seems to have been unclear, or rather didn't know, that any period of indirect was being suggested. Maybe, of course, once the judge had said, well, I want face-to-face contact to be, in effect, attempted further for a period of time. So yeah, he was looking at a 14 days of further attempts at direct contact on the basis that he did not consider the point had yet been reached where direct contact was simply not possible. My lady, I've already conceded that the reasoning given by His Honour, Judge Greensmith, is brief, and we see that very clearly from the transcript. My lady, we submit that the judge was not assisted, in fact, at that hearing, and had no reason, it wasn't made clear to him, that in fact the sort of process that had happened in February, acquiescence or agreement by the local authority, was in fact not going to happen after he had given his indication. Because, of course, had it been made clear to him, well, Judge, notwithstanding your indication, we are not, as a local authority, going to promote contact on that basis, the judge would no doubt have invited to make orders under Section 34, or to consider the making of orders under Section 34. My lady, we accept that the local authority's application for the Section 34 order, whilst we would entirely agree with the observations made by my lady that probably wasn't in fact the most appropriate application, but what it did do, the application, was put the issue of contact, the frequency, how that should take place, if at all, before the judge.
Well, it would have done if he'd known about it.
My lord, yes, but my lord, as to what he didn't know about, my lord, it appears, we submit from the transcript, that what he hadn't seen was the application itself. Clearly, some confusion was caused by it being made in Form C1 rather than C2,
yes.
and clearly difficulties locating it on the portal for whatever reason. He had seen the statement of the social worker,
which said that they'd made an application.
Yes. Hadn't seen the application, perhaps that's not entirely unusual, sometimes with difficulties with documentation reading judges. But he had seen the statement. We submit he had considered what was set out in that statement because he was aware, we submit, of what had been said by the child. He was aware of the reference to a mother being naughty, because indeed he asked a question about that himself. And was also aware and had seen the legal analysis document that had been provided by the local authority.
Do we have that in our bundle?
My lord,
It's been much referred to, but I don't think we've got that actually.
No, my lord, we had understood it was going to be included in the supplemental bundle. I don't think it is, in fact.
No.
In the supplemental bundle.
Perhaps that could be sent through.
Yes.
It would be helpful, I think, to have
Yes,
a
of
sight
course.
of that.
Mr. Heaney could perhaps
Thank you.
arrange for that, please.
Miss Burnell, I've listened carefully as to what you said as to the judge's understanding. But this is a 31-page transcript. It's not until page 20 that the judge raises a question. Mr. Heaney tells the judge that the local authority have made a Section 34 application. And we have the judge's question, is there? And he replies, yes. And it is clear, if I may say so, at least to me, that the judge was really ignorant of that.
My lady, it is clear that the judge had not seen the application. My lady, in fact, in the subsequent pages, we see there were efforts by the judge, I think, to then try and locate it.
Yes, that's right.
On the portal, questions at the bottom of page 21 about when was it lodged. So he clearly hadn't seen the application itself.
But he wasn't aware, my reading of that is he wasn't aware that an application had been made. Now, I know that he says that he's seen the statement, but I find that difficult to tie in with page 19 when he says that so far as he can see, there's not been a change since he made the order, made what he calls an order.
And can I just throw into the mix page 18 at the bottom,
Absolutely.
I'll say very clearly, if the local authority is incapable of complying with that order, an application should have been made to court. That's the first point. And an application had been made, even if it might have been the wrong one.
I accept all of that. The judge had not seen the application itself.
No, I'm sorry, we're not talking about this C1 or C2. We're talking about the fact of the matter having been brought back to court by way of an application.
My lady,
he's clearly not got that in mind at all.
My lady, I have to accept that. My lady, though it was clear from the way in which the way in which it was opened by Mr. Heaney that there was an issue as to contact.
Oh yes.
And that there was a dispute as to contact.
Well, the dispute was whether it should be once or twice indirect.
My lady, yes, and for how long? But my lady, the need for a reconsideration of the issue of contact was clearly, we submit, before the judge, from what had been said to him, and we submit from his engagement with things that were set out within the statement of the social worker that had underpinned the Section 34 application. Once the judge is aware of the application, and we accept my lord's point, it is late into the transcript. Once he is aware of the application, my lady, and so far as what he then does with it, well, I suppose two points arise. We look at it. Firstly, his ignorance of an application under Section 34, we raise a question whether that is, in effect, what leads him into error. My lady, we submit it doesn't, because, as I've indicated, the parties made it clear to the judge there was an issue about contact with which he needed to grapple, and there is a lot of back and forth as to the child and what the child has said, and that there may be any number of reasons for it. I don't seek to suggest that the issues raised by the local authorities to whether these comments stem from the child having experienced something in their mother's care or the allegations being right. Of course, that's a consideration. I don't seek to sidestep that. We simply say there are a range of possibilities, as my lord referred to earlier. So, him not seeing the application, my lady, is and not being aware of it at the outset of that hearing. Did that lead him into error? My lady, we submit that in and of itself didn't, because he was aware of the issues that he needed to deal with. The second point, insofar as him then adjourning that application, well, my lady, we say that of course follows from his consideration, the judge's consideration, that direct contact was appropriate for E.
How can you do that without any sort of a welfare evaluation? At all, anywhere?
My lady, it isn't there on the face of the transcript. My lady, we don't have a transcript of the hearing on the 27th of February, but my lady, I suspect it was dealt with in a very similar way.
But there's a statement from the local authorities saying why that agreement that had been reached was, in their view, no longer the right way forward in the interests of this child. And the mother had, through her counsel, agreed that that was the case outside court, and agreed that for the time being things should be slowed down and there should be now indirect contact once/twice a week. The judge says, no, I made an order, it's got to be direct contact. And Miss Mallon said, yes, please.
My lady, yes. My lady, because ultimately the mother's objective was to achieve direct contact, albeit she was and had entered into the discussion about whether that should be done at a slower pace for E, but that had not been able to.
If she hadn't entered into a discussion, she'd agreed.
My lady, yes, but as to how that was progressed, that remained an issue between the parties. My lady, of course, once the judge had expressed that view, in effect we submit the same process should have happened as happened in February. should have been an opportunity for that to be considered, and if it remained an issue, then the judge should have been informed and parties could have made such applications as they needed to make. Or the judge should have been invited to expand upon why it was. He was saying that direct contact was appropriate for E at that time.
So just so I'm clear about the current position, your current position on behalf of the mother is that the appeal should be dismissed on the basis that an order has been made by the court below that there should, notwithstanding there's been no welfare evaluation, of direct contact commencing forthwith.
My lord, sorry, my lady, it's that this should be dismissed on the basis that all the order does is recite the judge's view as to contact. If the local authority not going to...
No, the judge thought he was making an order. And it's been conceded by the local authority that given the judge's approach, that it should have been in the form of an order, not a recital. So I'm asking you, what if your position today is that effectively what this court should do is substitute the recital on the basis it was wrongly made, it should have been made an order, with an order for direct contact to start forthwith.
My lady, the mother accepts that a further period of indirect contact is needed. My lady, we have sought to engage with the local authority as to how that could be progressed. And to have, my lady, the route map phrase has been used earlier today, but to have a plan. My lady, the mother has not applied for an order because she recognises there will be a need for some fluidity around any plan moving forward. So we do not seek to have something set in stone, as it were, in the terms of an order.
So I'm really struggling to understand what you say the outcome of this appeal should be in that case. Because if the mother very sensibly and appropriately accepts there needs to be a further period of indirect contact, how can you possibly say that the appeal should be dismissed on the basis of a recital, which the judge says was an order, for direct contact forthwith?
Well, my lady, we concede the recital is not an order. The order is as drafted and approved by the court. My lady, I hear what is said by the local authority insofar as conceded that it should have been drafted as an order, and the judge says in terms I'm making an order. But of course he also says, well, the previous recital was an order. So whether in fact he intended to make a section 34 order, my lady, I fully recognise that that's what he says. But in fact he doesn't engage with it being an order under section 34 or whether it's a recital, because in the judge's view, erroneously we accept, a recital has the same effect as an order. So on the basis of the approved order, my lady, we say that...
Sorry, the recital says, I've just gone back to the recital. Direct contact should commence no later than Tuesday, 2nd April 2024. And you're saying this appeal should be dismissed on that basis.
My lady, yes, my lady, we are not inviting the court to substitute it as an order. The recital was drafted, it was approved by the judge, and my lady, we are not inviting the court to now make an order for direct contact. So my lady, in effect, as an appeal against a recital, my lady, we say it should be dismissed. If my lady takes the view that in fact the order is erroneous on its face and there ought to have been a section 34 order.
Perhaps I'm misunderstanding you. As I understand it, what you're saying is that contrary to everything in this recital, it is now accepted, and contrary to what was the position at the end of the hearing, the mother's position has gone back to the agreement made outside court, namely there needs to be a further period of indirect contact. But you're saying that notwithstanding that, and that it's wholly contrary to what's in the recitals should stand.
My lady, as a recitation of what the judge's view was...
But it actually says direct contact will commence on a certain date, and you're now saying we agree that isn't in the welfare interests of the child.
My lady, it says contact's going to start on a certain date, and of course that order was stayed, so that in fact that hasn't happened. My lady, there was also a gap in indirect contact. I think when the social worker was absent and the mother very sensibly agreed it shouldn't be facilitated by somebody else. So my lady, here and now, the mother simply cannot say, and it wouldn't be responsible for her to say, I want my direct contact later this week or even next week. There is clearly a process that needs to be gone through and a process that this child needs to go through. My lady, we do want to enter into discussions with the local authority. The mother wants to have those discussions about, well, how frequent is it going to be and for how long before we review the progress of that contact. And my lady, perhaps we are somewhat dancing on the head of a pin, because as a recital, it reflects what the judge said. I concede that that recital is not the same as an order. My lady, I've made that clear. The mother has not applied for Section 34, an order herself under Section 34. Again, we submit sensibly, given where things are at. So my lady, I suppose, insofar as whether or not the appeal is allowed as an appeal against a recital, maybe that's where we stand insofar as saying, well, almost what is there to appeal? My lady, we understand the observations, the issues that have been raised insofar as the judge's approach is concerned. And my lady, I hope we've addressed those within our skeleton argument, particularly insofar as, and orally today, insofar as actually the assistance that ought to have been provided to the judge, insofar as everybody being quite clear within that hearing as to what was going to happen following on from his indication. Because however strongly that indication was, there had been a process in February. Agreement had been reached, or acquiescence. That's not unusual, and perhaps again that ought to have been made clear to the judge, so that this issue, if it had to be determined, not on the basis of this case it does, could have been determined there and then, and he could have expanded upon his reasons. If the judge had gone on to make an order in the terms that he had already indicated, then no doubt we would still be here, and the local authority would be appealing that order, but on the basis of one would expect a fuller judgment setting out his reasons for making that order. Lady Millward, can I assist with anything further at this stage?
One point. Just in relation to the February recital, is it any part of your case that the local authority were acting in any bad faith in agreeing something that then didn't happen? Or is it your case that everyone was acting in good faith that a particular roadmap would be followed, but that, as it happened, E's reaction to the first video call contact was such that the roadmap took a different direction after the 6th of March?
My lord, we don't assert bad faith on the part of the local authority for the events following on from...
They were reacting to a situation on the ground.
Absolutely, and my lord, I hope that is clear from the cooperation that the mother then gave with the changed plan, and in fact the very fact that she did not immediately make an application under Section 34.
Of course.
She recognised the need to have flexibility to that approach. So we don't assert any bad faith. My lord, in fact, raised a question to my learned friend earlier in relation to what had happened between January and February. My lord, we're not asserting bad faith in relation to that, but we do say that there was a deficiency in the way that the local authority approached matters between January and February. We recognise, of course, the mother's bail conditions were a consideration. But, my lord, that is not unusual where a parent is facing any sort of serious allegation, and there are bail conditions that may or that will impact upon what arrangements can be made for contact. It is not at all unusual for there to be liaison if there is a proposal for contact, neither those representing a parent within the criminal proceedings seek a variation to bail on the basis of a proposal that has been made. So we submit that actually the fact that there was a bail condition didn't obviate the need for the local authority to meet its duty, and I think that is conceded by the local authority. And of course we've referred within our skeleton argument to the observations made by the Guardian when she filed her initial analysis about the absence actually of any rationale as to why contact had not been facilitated, what the plan was, and how the local authority had carried out that risk balance, welfare balance assessment at that stage. So we do say there was a deficiency. I'm not saying it's bad faith. It is perhaps one of those things that happen, but to be absolutely clear, we don't assert bad faith following on from February.
Thank you very much. That's very helpful.
Thank you very much.
Yes, Miss Edmonds.
My ladies, my lord, thank you. You will have considered my skeleton argument.
We have,
I
which,
hope.
if I may say so, was excellent, and each one of us separately commented on its quality. So with that, thank you.
I'm grateful, thank you. Within that document at paragraph 8, I set out the Guardian's position on behalf of E in response to this appeal, and the reasons for that proposed outcome that we invite this court to take are set out at paragraph 45. My ladies, my lord, I don't intend to rehearse what is contained within that document, but if I can just very briefly deal with 3 matters that have arisen during the course of this hearing. The first one relates to what I might term as housekeeping. I wasn't present at any of the first instance decisions taken in relation to these proceedings. I've spoken with my instructing solicitor, Miss Roberts, who did represent the interests of E at both hearings. Her recollection in respect of the February hearing is that once the learned judge had expressed his view on what should happen in relation to contact between E and her mother, the parties in my submission quite properly asked for time to have collaborative and cooperative discussions outside of the courtroom, and agreement was reached. And of course, the court sees that set out on the face of the order. Miss Roberts does not recollect, and she's reviewed her notes for me this morning, going back into the courtroom for the learned judge to endorse that approach. Her recollection is that what then happened is the agreement contained on the face of the order was then lodged with the learned judge for his approval that way. So a slight difference in recollection. I suspect it probably doesn't help in terms of the decision this court has to take, but simply set that out for record. The second matter I wish to address is the discussion that is taking place as to the distinction between recitals and orders in relation to Children Act proceedings. The court will see that the House rules are referenced within my skeleton argument. As I say, flowing from that, it is very clear that recitals clearly have a place, they have a purpose, limited, however, in the execution of those objectives. What I say is the difference in distinction between recitals and court orders is that recitals allow for an audit trail, in effect, to be captured relating to relevant decision-making of a child, which may then in due course assist the court in assessing accountability or other matters flowing relevant to any issues pertaining to the resolution of the proceedings. And so, as I say, it creates the ability to look back and have a record where necessary. What a recital does not do, which an order does, is create a movement towards enforceability. And in my respectful submission, that is where the learned judge fell into error at the March hearing, because he adopted, if I may say so, with respect, a fixed mindset at the outset of the hearing, whereby he had very clearly reassured himself that what was recited on the face of the February order was in effect a court order that had been disobeyed. And therein, in my submission, the process that then followed became contaminated, compromised, and confused. The process in my submission certainly became contaminated. Critically, from E's perspective, her welfare needs at that March hearing became compromised. And the outcome, the output of the hearing as reflected in the sealed court order, on any view I would suggest, became confused. The third issue I wish to address the court on relates to welfare from E's perspective. In my submission, when a court steps back and considers the factual landscape of this case, E's needs, given her age and her life journey so far, demonstrate that those needs were both evolving and fluid. In my submission, that required the learned judge at each hearing where the issue of her welfare needs were being considered to pause and reflect and to take into account the updating information as relevant to those needs. But for that to be looked at through the lens of the welfare checklist, and as this court has already identified, there is no reference at all, unfortunately, to the provisions of the welfare checklist. I recognise, as has been said on behalf of the local authority, that judges operating in the family justice system are under a lot of pressure, and time is very precious in terms of decision making. And sometimes it can be said by an appellate court that drawing the threads of any particular judgment, it's implicit that the judge at first instance clearly had the welfare checklist front and centre of decision making. Unfortunately, reading the transcript of the March hearing, it is difficult to pinpoint how the learned judge had the welfare checklist front and centre of his decision making. And I suggest that because of the mindset that had been adopted by the learned judge, there was then a compromising of his ability to properly, fairly, and of course, up to date in that moment, review those welfare needs through the prism of the welfare checklist. And so it is for a combination of reasons, as I have set out within my skeleton argument, that on behalf of E through her guardian, we would support the appeal, and as I have indicated within my skeleton at paragraph 8, the way forward in response should this court accede to the application insofar as that it should now be remitted to the designated family judge for further consideration. There is clearly, aside from the appeal and the merits of the same, some understanding between the parties as to what is happening on the ground in relation to E's needs and with particular reference to her contact and relationship with her mother. And so I don't depart from what is set out at paragraph 8 in terms of those arrangements continuing, in terms of the contact being promoted at a frequency of once per week through FaceTime. Of course, I say within my document that, and of course I accept, hindsight is a wonderful aspect of appearing within an appeal court, but the section 34.4 application maybe wasn't absolutely necessary at that juncture, because on any view, the local authority were committing to the principle of maintaining some contact between E and her mother. Whether that was appropriate or reasonable, of course, becomes a secondary consideration. And it may have been that if there was an active dispute by the mother at that hearing, that the onus would have fallen to her to make the application to tease out that issue before the learned judge. So I don't invite the court to do anything by reference to the section 34.4 application. My ladies, my lord, trying to read the room as best as I can, I hope I've dealt with the matters that have arisen as the hearing has progressed. Is there anything that I can assist the court with at this stage?
Just looking, I think it's actually paragraph 7 of your skeleton argument, but looking at C, pending a further hearing, the local authority continue to promote reasonable contact via supervised FaceTime to frequency of once per week. Is your submission that this court should make an interim contact order? I don't think we'll be up for making a recital.
I would suggest, for the reasons that I've set out in my document, that when parties do agree on what is appropriate for a child,
there's no need for an order.
The no order of principle
Right.
takes effect and bites. And I would suggest that that is adequate in these proceedings.
So your a proper interpretation of C is that, given what all the parties have said in court, the only orders that this court, in your submission, should make would be that the appeal be allowed and that the matter be remitted forthwith for urgent consideration by the designated family judge.
Yes.
Thank you very much indeed. Anything? No, thank you very much, Ms. Edmond. Yes, anything in reply?
No, my lady.
Thank you. Perhaps, can I just come back to you for a moment, Ms. Burnell? Just that last point I raised with the Guardian, I didn't and should have raised with you.
My lady,
In the event that we allow the appeal.
My lady, I don't invite the court to make an order. My lady, we entirely join with the point that the local authority had raised within its document as to whether the 34 order was in fact necessary. My lady, this is perhaps an interesting point, and I think different local authorities sometimes take different views as to whether, in fact, if they're not promoting direct face-to-face contact, there needs to be an order authorising that. But my lady, we submit that the statute is clear on its face. The local authority is promoting reasonable contact, and the guidance of the Children Act covers all forms of contact. So, my lady, if there is to be contact of one form or another, we submit then a 34-4 order is not necessary. So, my lady, given that the local authority, so we said nothing is needed on the 34-4, the local authority is promoting a level of contact. It says once a week, indirect. And my lady, in due course, if matters cannot progress and there is an issue, then of course it's incumbent upon the mother to make an application, or indeed the child to make an application at that stage. So that's probably a rather long-winded way of saying.
It's extremely helpful. I'm much clearer in my mind now. Shall we rise? We'll rise for a few minutes. All rise if able.
Have asked for a document, the ladyship's even asked for a document to be emailed. I don't know where to send it to.
Send it to Civil Appeals Associates. Alright, have you got that one?
Civil Appeals.
The legal framework, then? Yeah. Can you send it to me? Just because
Yeah.
All rise if able.
Mr. Heaney, we're going to allow the appeal. Looking at the totality of the order of the 22nd of March, it seems to us that what needs to be removed from the face of the order are the references in paragraph 4F to I of recitals. We note that there's a large number of case management orders, and it may be that they're rolling along, it may be that they need reconsidering. So what we propose to do is to remit for urgent consideration as to interim contact and any further case management the matter to the designated family judge, who I think is Honour Judge Parker.
Indeed.
And it follows that there is no need, and neither is it appropriate, given the indications that we've had and the submissions we've had, for us to make any orders in relation to contact for the time being.
Lady, yes.
Now, a judgment will obviously, giving our reasons, we will produce as rapidly as possible, but we have given the outcome of the appeal because it's very important that this matter is not delayed, even for a matter of weeks. Please, could you take carriage of the order of this court, be it obviously agreed between the parties, and I wonder if you could also take carriage of communicating with His Honour Judge Parker that we're looking for an urgent listing, even a short directions hearing in the first instance, so that this matter can be back on track.
Indeed,
he can consider what has to happen in the meantime and whether or not the matter needs to be reallocated, and we make no comment or express no view about that.
Of course. Yes, my lady.
Now, is there anything else that we can usefully do to ensure that any delays?
Don't think so.
No? Thank you. Well, thank you all very much indeed for your very helpful and economical submissions and written material. On behalf of us all, we hope very much that the matter can now proceed as rapidly as possible for the sake of it.
Thank you.
Thank you all very much.
All rise if able.